The people are just due process. That is a very fundamental right of our government, form of government. Just if we're going to say that just because the legislature won't follow what I call over there, somebody calls over there and asks them, they don't follow it, then there's no First Amendment right. I think that just the process of having notice, and I think there are two quotes that Justice Randolph was in the 2008 Barbour v. State said that no governor, for that matter, or any government official can exercise power beyond their constitutional authority. And I think that what we're talking about here is the governor has invaded not only the province of the judiciary, but violated the constitutional rights preserved by the people.
Well, I think, General Swear, you're not defining your argument correctly on the separation of power issue. The reason I would surmise that we don't look at legislative acts when they pass spending bills is that's the job of the legislature to do spending bills, and we're not going to interfere with that other branch of government. And they should not interfere with ours, and we should not interfere with the executive. So, but I think the argument that you're failing to bring to fruition is that the people retained the right, had the right to grant pardons. That is not a branch of government that we're dealing with. It's the people. All powers inherent in the people. And they chose to use three branches of government. But if this court is going to interpret the Constitution, what we're looking at is how it affects the people, not the other branch of government. Is that right that was retained by the people being usurped by any branch of government? And I think that's the argument that we have to analyze.
Thank you, Your Honor. You said it much more concisely than I have in nearly an hour. That is the gist of our argument, that it was preserved to the people. They first gave it to the governor in 1832, and in the 1869 Constitution, the governor had no limitations. And then they took it back and they said, you don't have this power unless and until you do that. And it is a constitutional right preserved or reserved by the people who give the power. The governor doesn't have any common law authority. The governor only has the authority. And there's cases, actually, that the governor just has the authority that's given by the Constitution and statutes. And so, in this case, when it's clear that the people gave that right back to themselves and preserved it, say, Governor, you don't have it until the publication occurs, I think is a clear violation. But I think it also does invade the province of the judiciary. And
I'm having trouble understanding why that's different, though, than the people saying the same thing to the exact same thing to the legislature. You don't have the power to pass a certain kind of bill in the last 5 days of your session. The people have reserved. The legislature has no power except that granted by the people. It's the people's power to pass their own laws, and they delegate it to a legislature, same as they do to a governor. With respect to the governor's powers, and the people said the same thing to the legislature. They said you can pass bills, you can pass revenue bills, but you are constitutionally prohibited from passing revenue bills introduced in the last 5 days of the legislature, and yet they do it, or they did it. And this court said we're not going to look behind that. I'm really having trouble seeing why there's a difference.
Your Honor, if were I judge, I would think that the legislature ought to follow the law. I suspect, just knowing that they can move deadlines and when it ends and all that, the court just says, look, we're not getting into the inner workings of the legislature.
I can understand if you say the case was decided wrongly. If you take the position that this court decided the case wrong and should not have said that, we should have said the Constitution. We should have said, if you take the position, they should have said in that case what you're saying here today, the Constitution is a Constitution and this court ought to look behind it. And if the legislature passes a bill introduced in the last 5 days, we ought to set it aside. That argument I understand, but I do not understand the argument that you're making that's different. It's different when it's the legislature as opposed to the governor, and the power granted by the people to the governor as opposed to the power granted by the people to the legislature. What's the difference?
I don't know. That's the reason I would have decided that. I would have followed the Constitution.
You think the case was wrongly decided?
Yes, sir.
Now I have no more questions about it.
Yes,
That's all I was asking.
yes, sir. But I think that there's just a feeling, and this court has been very courteous to the other branches of government, given a lot of leeway to give deference to agencies that interpret their statutes. And rightfully so, because the judiciary controls that separation of power. But, violation of a statute may be one thing, or interpretation of the statute may be one thing by an executive agency. But the Constitution is for the court to interpret. And as Justice Dickinson said in this Barbour v. Berger order, to allow an agency to interpret, its own rules and by statute is one thing. But it's for the court to interpret the Constitution and interpret it strictly. It is a constitutional reservation. So that's why I say this court has a duty to interpret the constitutional language of this very simple constitutional provision.
You heard the argument made by Mr. Fortier and others about there should be a distinction between the procedural language of 124 and the substantive language of 124. What do you have to say to that argument?
I don't think that dichotomy properly describes that constitutional provision. I don't see it as procedural. I see it as a substantive right that the people have reserved unto themselves of notice. And whether or not that would change the governor's decision is irrelevant. It's the people who reserve the right to notice and an opportunity to comment. Due process, our foundations of our government.
Well, it seems to me that the discussion that's been made in most of these briefs is Article 1, Sections 1 and 2 on separation of power. In looking at Article 3, Section 32, it says the enumeration of rights in this Constitution shall not be construed to deny and impair others retained by and inherent in the people. And do you think the manner in which that the arguments are being made to validate these pardons is impairing or denying rights that were retained by the people to start with?
Yes, sir. I think that, the actions of violating the people's constitutional right is where it gives the judiciary an opportunity to step in and determine whether it's properly followed, and I think that it's been violated with these pardons. So I agree it's the people's constitutional right that was reserved.
Well, it's a greater right than a constitutional right. It's the ultimate right. It's a natural right of the citizens before they ever form a constitution.
Yes, sir. The pardon power it's a sacred power that we grant. Some states give it to the legislature or to a pardon board, for example. This pardon board that was established by statute, it was discretionary, by the way. That one in 1916, it was discretionary as well. The governor had to follow it. But some states have done that. But it's a sacred power that's been used sparingly historically by governors. As I said, Governor Waller granted 1, Governor Finch 0. That's what we can find. Governor Winter 1, Governor Lane 0, Governor Mavis 4, Governor Fordyce 13, and Governor Musgrove gave 1. Now, many of them commuted sentences, and there were uproars about that. But there again, that publication requirement doesn't apply to the commutation of those sentences, and it's our position that certainly that this court, a court, would be invading the province of the governor if you look into the wisdom of the case. But if you look at whether the Constitution was followed, whether it violated the people's right to notice in 30 days notice, and I think that was put in there to have a cooling off period, to give us time to publish and people to have comments so there wasn't a last minute rush, and for there to be errors in the pardons themselves. And so I believe there's been a violation of the people's constitutional rights, and I believe this court has a duty to correct it. And the method by which I believe that the court should correct it is by avoiding these pardons. And so I respectfully request that this court remand this case with some direction on what's 30 days. We've given a lot of cases. One case cited, I think, 60 cases of those older cases that we cited. It gives some direction on the 30-day period, but we certainly believe
to do what you're requesting. Honestly, it appears to me as though we must find, as you do, that Hunt case was decided wrong. Montgomery case was decided wrong. And the Pope versus Wiggins case, as I read it, seems to say exactly the same thing as those two cases do. That the judiciary is prohibited from, in my own words, second-guessing the governor as far as his decision pertaining to the sufficiency of the evidence prior to granting a pardon. And I know you're familiar with that. Do you think the holding in that case is also?
Justice Chandler, I apologize. I lost track of the question that you asked. I understand what you're saying about the court's decision on the legislative issue of whether or not you dabble in that. I say that's different. I say it was decided wrong, but it doesn't have application in this case as to whether the people's right was violated. Now, the last part of the question, sorry, Mama.
Well, the language in Pope, it seems to me to be very similar to the language in the Hunt case, where it says, referring to the governor, he is the judge of the sufficiency of the information from whatever source in determining whether he has a reason that he is entitled to deem sufficient for his action, referring to his pardoning action.
Your Honor, the distinction that I place here is the propriety or the wisdom of making those pardons of who he grants it to is one thing, but whether he complied with this constitutional provision is just a legal issue, a dry legal issue for the court to consider. I'm sorry, I don't really understand how that, or I can't articulate how that applies in your question, but I do believe that it is just strictly a situation where you read the Constitution and apply it as it's written.
Hood, I have a couple of questions for you. As I understand what you said earlier, and you repeated it a few moments ago, that those lesser powers than pardon, lesser clemency powers, that is the suspended sentence, the commutation of sentence, do not require the 30-day notice that you say applies to the full and conditional pardons. Do I understand you on that?
Yes, ma'am.
All right. As we probably all can acknowledge, this case, this hearing today, is really in a rather unusual procedural posture. No doubt we have expedited briefing, arguments, etc., because of the posture of the case. And I understand that there are 10 individuals before us today. These are the cases that we are looking at that have filed for relief from this court. And last week, we stayed the proceedings in the lower court. We also left that TRO in effect, which had to be granted until this matter could be sorted out. Are there people being held in Parchment today who are holding a facially valid grant, a commutation of sentence, a medical release, whatever you want to call it, on the basis of that TRO?
No, ma'am. We agreed that only those that were subject to the TRO were those 5 that actually received a full pardon.
So there are no people being held in Parchman today that were the subject of the 13 medical releases or the conditional indefinite suspension of sentence. Those people have been released from Parchman?
Yes, ma'am. David Scott was here with MDOC, and he indicated that that they were. We never contested.
So Robertson, Tate, Brown, Howard, and Cambouli are the 5 that are being held today. And only those 5, correct?
Yes, ma'am.
Let me follow up on that, General Hood, regarding numbers. At page 4 of your brief, you say approximately 122 of the pardons were issued to felons who either began publishing. Let me skip on over to the conclusion. To date, 22 felons have been determined to have satisfied the publication requirement, and their pardons are not challenged. So of the 215 minus 22, that leaves 193. Are you challenging the 193, those 193 pardons?
Yes, Your Honor. We're challenging all but the 22 that we have found that publication was properly done, and we submitted an order to the court or draft order saying that they were we weren't not contesting those 22.
So, and I know we've got only 10 before us, but obviously any decision that we make, would you agree, would affect the other 183?
Yes, sir. We found that 56 didn't do any publication at all, and that the others were insufficient. Many of them published for maybe once a week for 4 weeks, or these 10, they didn't get, there wasn't 30 days before the pardons were granted, the 10 that we're dealing with, so it had to be published 30 days prior to. So that occurred in many instances, that those weren't done, but the ones that were, many of them just didn't publish the right amount of time, but 22 knew how to do it.
And none of those are in custody?
No, sir.
I have one question. A couple of the briefs raised an issue, didn't really give us much argument, and they referred and adopted somebody else's brief. And I didn't find where you responded to the issue, and I'm not sure you had to since there wasn't much argument there. But I am curious, in the event this court were to determine that this case had to be sent back to the trial court, at least the issue was raised that the assignment of the case to the trial judge was done improperly, that I think the original application went to one circuit judge, and that the random assignment process was ignored. Do you have any response to that argument?
Yes, Your Honor. Their rules say you have to go down to the clerk's office and file it in Hinds County, and it's assigned to a judge. But if that judge is not there, then you go to the judge that was available. And so that's what we did. Judge Green was there. She, by her own order, we're not going to argue to go behind her order, but she talked to the judge who it was originally assigned to, and they agreed that it be transferred to her. That was in her order, so we didn't make any argument behind what she had already said in her own order.
I recall the order. I think it was assigned to Judge Will, and he was in trial, and so they talked, and she took it over.
Yes, there was a criminal trial going on down at Raymond. That he was in that trial, and that's how it wound up in her court.
I know you don't agree with the harmless error analysis if we get to that point, but even let's assume that we do decide jump through all the hoops to get to the point to say, okay, we're going to apply a harmless error analysis. Then would you agree that the test would be, but for the failure to publish in the paper, there would have been a different outcome by way of what Governor Barbour would have done by way of the pardons?
I'm sorry, Judge Carlson.
Okay, just the general. We all know, that the harmless error analysis that, let's say in the criminal context, but for this constitutional violation, the outcome of the trial would have been different. But for the constitutional violation here, assuming for the sake of argument there was one, the outcome of the pardoning process would have been different. Would you agree that would be the test?
Yes, sir. I'm not sure about the test. I would suggest that it doesn't really matter what the outcome would be. It would be that whether there was a constitutional violation. And so he doesn't have that authority to pardon. There wouldn't be any pardons if he had followed what the Constitution says, what our position on it.
But going back to what we've said, and you arguing, and many times quite successfully, on appeal in your office about harmless error, and that regardless, based on the harmless error analysis, the criminal conviction will be affirmed. So I'm asking you, though, that if we get to that point, knowing you disagree with it, would the test be then, but for the constitutional violation on the 30-day publication notice, the outcome of the pardoning process would have been different? In other words, Governor Barbour would not have pardoned this person or that person based on the failure to follow the Constitution.
I'm not sure, Judge. You know, Pontius Pilate had to go before an angry mob when he pardoned Barabbas and not Jesus. I don't know what the impact would have been, but I think there would have certainly been public uproar from the people had this notice been properly done, because you see what's happened after the fact. And perhaps the governor may have changed his mind, but I don't think that what he may have done, whether there was comment or not, still that notice was required, and when it's not done, that act is void, and it's just like the partial veto case.
It'd be fair to say that as I appreciate your argument, when you have a condition precedent, for instance, if there were a condition precedent to a prosecution, you can't have harmless error. That unless the condition is met, there can be no prosecution, and therefore no need for a harmless error evaluation. And where there's a condition precedent to the pardon, you never get to a harmless. You never get to a harmless error argument because the pardon was void to begin with, so you can't determine. It doesn't matter whether it was harmless or not. There's no pardon. Is that what you're saying?
Yes, sir. I say that there is no pardon, because the pardons were invalid and because the Constitution wasn't followed. So it couldn't be harmless because it's violated the people's constitutional right. And I do say it is an invasion of the province of this court, because there were valid orders of sentence given, upheld, and by these actions it invaded the authority of the court, and the court has to protect its authority. I know that the court has been very courteous and making sure that it doesn't overstep its boundaries. Very touchy question, and all judges weigh that very heavily before they take some action. But we can't have executives interpreting constitutional law to the exclusion of the court. And maybe giving them deference on the interpretation of the statutes that affect their office, but not when it comes to the constitutional rights of others. This isn't just involve the constitutional authority of the governor. That's part of that section. But it's the constitutional right of the people that was reserved in 1890. I think it's a violation of their rights, as well as a violation of separation of powers and the authority of the people. I made it a lot longer than I ever anticipated. It's 7 minutes left. Unless y'all have any other questions, I will be glad to take my seat. The state of Mississippi respectfully requests that this court find that it is reviewable by a court, that the governor's actions were in violation of the publications of these 10. If you're uncomfortable with that, to remand it and allow the circuit court to find the facts necessary to make the determination on these 10 as well as the others. We would like some direction, if possible, as to what the 30 days means. Our position is that 30 days means that you have to publish, if it's a daily, every day for 30 days. If it's a weekly, you have to publish for 5 weeks, so that you would be covered for the entire 30 days. If it's like Oxford Eagle, published for 5 days every week, then you'd have to do each 5 days and then 2 more to get to 30. And 30 days means 30 days, and the Constitution horseshoes is close enough. But when you're interpreting the Constitution and the number of days that people put in it, and taking into consideration what they knew what it meant in 1890 to say 4 weeks, published for 4 weeks. They were exact in their statement of 30 days, and so it's our position that 30 days is 30 days, and you have to publish, and the simple way we've determined that it applies is every time that paper's published. You know, they knew this. There was some weekly papers and bi-weekly papers back then, and then there was a daily Clarion Ledger here. So every time it's published, you got to have it in there for 30 days. You know, it's like if you say I'm going to the beach for 30 days, then you don't anticipate somebody coming back during that period. And so we would ask the court to give us some direction as to what 30 days means, so that when we do go back down to the lower court, we can introduce the pardons and introduce the proof of publication, which we have in all of them but two. There's some orders holding up the papers from granting us two, and allow us to introduce those, and those issues will be much more simple, easy to handle. It won't be any retroactive application of law to violate anybody's rights, and I will take my seat.
What was published in those 22 cases that you have deemed to be sufficient? What was published, and how was it published?
It was published. I'm not sure on each one, Your Honor. I know it went over 30 days. Whether it's, I'm sure some weekly.
What was it? What did they publish?
The Constitution does say the petition, but newspapers won't let you always publish the exact language or the document that you prefer. And so the Constitution, it was that I'm seeking a pardon and the reasons why is what the Constitution required.
So in none of those 22 cases was the actual petition published?
I don't think so, Your Honor. The papers, you have to understand that some of the papers don't let you publish the actual document that you're requesting. That's my understanding.
The Constitution says it's not his petition for pardon setting forth there and the reasons why such a pardon should be granted. So say the newspapers are deciding that instead of the constitutional language petition for pardon, they're going to paraphrase. I hadn't thought about that till Justice Lamar asked you.
That's exactly right. I looked at that too. It does say the petition's got to be, but we're not contesting whether it was what it's called was published. As long as they're saying it's.
I guess that's what I'm asking is why, and that's what my concern is. Why are we concerned about the letter of the law and some words that are used in that constitutional provision and not in others?
Well, I'm concerned about people getting notice for 30 days. As far as it's just notice, and so it doesn't have to be exactly every reason that they think that they'll get a pardon. I would think just logically interpreting it. I think, but it's the basic tenet here is that it's notice and an opportunity to be heard. And so if it says I'm seeking a pardon and gives a reason why or something like that, I think that would be sufficient to comply with the intent of the constitutional provision. But if you allow an officer of the executive branch to interpret the Constitution and say, well, I'm just going to grant a pardon, I don't care about this application process or 30 days, and if we give that interpretation power to an executive, they can just write that whole section out of the Constitution.
General, with all due respect, when someone submits a petition to a newspaper, and the newspaper decides we're not going to publish this whole thing, we're just going to publish what we think should be published, and then you look at that on 20-something cases and say that's okay, aren't you, as an executive member of the government, doing the very same thing that you're saying can't be done?
I understand your point, and I don't know what the 22, as I said, I don't know what it said. I didn't look at each one of those. I've had assistants handle that. But I would assume, just assuming that it just had, notice and it said that I'm seeking a pardon and gave some reasons therefore. If the court feels that I ought to challenge those as well, that will be what I'll do. I'm an officer of this court. Our office is a branch of the court to enforce the laws and the Constitution within reason.
I seriously doubt we're going to tell you what to challenge.
We've already conceded that those 22 we think properly published. And we're just trying to use the best judgment we can. This is all a new area of the law have to deal with.
But you're telling us you can use your best judgment, but the governor can't use his best judgment, it seems to me. If I don't mean to put words in your mouth, but that's what it kind of strikes me as being.
No, sir. What we did is we went out and actually looked at publications. The governor signed 56 in which there was no publication whatsoever. And
some of those had no applicants either, did they?
Some of the 56?
Some of these before us today, nobody asked for a pardon. You just gave them.
The ones at the mansion, I suspect they did. I mean, that's just a factual debate.
Now, John, you can't,
They didn't file an application. Yes, sir.
what you suspect doesn't count, does it?
No, sir. No, sir, it
Let
doesn't.
me ask you this, because I've had a lot of interest about the application process. So the position being taken, as I understand by the petitioners here, that I never asked for nothing and somebody just walked up and gave me a pardon for murder. And I'm having a hard time swallowing that. You know, I've never had anybody just walk